Well, good afternoon, everybody.
Brad, Rosie, and Nick.
Good afternoon.
Good afternoon, Judge.
All right. So is Mr. Rowe. Oh, Mr. Rosie, there we go.
I can pin a certain person, Judge.
I'm sorry?
Do you want me to pin somebody in the middle?
Doesn't matter. Okay. Can we unmute everybody, please? Yeah, I'm not sure if Westville will allow him unmuted. I'm not sure, 'cause that's on their end.
I think, well, looks like he's looking.
Okay. He's checking at the door, apparently. Okay. Hey, Mr. Allen, we can hear you now.
Oh,
We can hear you now. Thank you.
sorry.
Okay. No, that's okay. That's fine. I know, originally, you were muted and we couldn't hear you, so I know you were clamoring for somebody to help, but our IT person got you unmuted. All right. We are here on State of Indiana versus Richard Allen, 08C01-2210MR1. I'll show that Mr. Allen is here with Mr. Baldwin and Mr. Rosie. The state is here by Mr. McClelland. With the consent of the parties, we are doing this by Zoom so that we can address the defendant's petition to let bail. Mr. Rosie, you filed a motion to continue that hearing, as well as a motion to continue the trial. You may proceed, sir.
Judge, you'll have to forgive me, the inaudible audio feedback. I'm getting a lot of feedback.
George?
Is that from the jail or us?
Maybe from the jail.
Okay.
Okay.
Yeah, I'm still getting inaudible audio feedback. Judge, I think you asked about our motion to continue.
Yes.
Not only inaudible, obviously, the volume of discovery is inaudible, between the state and the defendant is significant. That's an understatement. Mr. McClelland has worked, inaudible, as have we, to arrange for things, and I think the Reeves 5 or so hard drives, with several terabytes of information.
What is that?
That, can you hear me up there?
Hold on just 1 second. Can you mute Mr. Allen? I don't know if it's coming from there. All right, Mr. Rosie, try again.
Go ahead.
There we go.
So it's there. That's a little better.
Okay.
The state had offered up, some discovery on Monday, and we just haven't had a chance to really even to dig into that at all at this point. And there's just no way, practically, that we can move forward with a bond hearing without at least having, reviewed on a basic level the discovery that's been offered up. And I'm guessing it's probably gonna take us, for 8 weeks to catalog this information and, essentially, just get some idea of what we're dealing with. There are some hardware challenges and some software challenges that come with that. I think we were informed by Mr. McClelland's staff that it's gonna take over a day to just download each of the disks and the hard drives independently. And I do think that there are a few of the hard drives that I understand may have some problems. They're having some problems with the audio. Those are things that Mr. McClelland's office and my office can work through. But we've also had some discussions about the possibility of taking some depositions. So I would anticipate, to kind of get to the heart of the matter, that we would want to set this bond hearing or this bail hearing out probably into May.
Okay.
Maybe mid-May might be appropriate.
Even June.
Maybe June.
Okay. And, Mr. McClelland, you've indicated, what is your position?
Judge, I have no objection to that. I understand the defense's motion. I filed a response to that motion not objecting to continuing the let bail hearing. I also have no objection to continuing the trial date. As well, Judge.
Okay. 'Cause I know we had talked earlier about discussing the March trial date and bond hearing. Obviously, if we're looking at a bail hearing sometime in May or June, CL Early were also, and you've also asked, Mr. Rossi and Mr. Baldwin, to continue the trial. I anticipated that that's where we were going to be with this, so I don't see that we really have any issue with continuing everything. Do you wish to give me some dates, mid-May and June?
I wish I'd brought my glasses.
Judge, I guess it's kind of one of those cases where, for the most part, I'm willing to make accommodations to the court's schedule, knowing all the logistics. I don't have anything. I know I have one case that would matter that would require, us to set aside a whole week. I think that's in July or August, though. I'm pretty good with any dates that can happen in May through most of June.
Okay.
Judge, this is Nick McClelland. I'll just inform the court that the court's trial calendar. Our trial weeks for May and June are the week of May 15th and then in June, June 5th. And I believe that covers us for both those months in terms of what weeks are set for jury trials in circuit.
Okay. So those are weeks that are not available for you and the court.
Those weeks I'll be in trial in circuit court, and the circuit courtroom will be used for trials those 2 weeks, Judge.
Okay. I've got Jody looking now for a Friday in, without those dates in May or June, Jody.
Judge, the court reporter for circuit court also told me that Judge Diener's gone the week of June 26th, and so I know that's a little bit later than what defense had recommended, but that week is wide open in terms of hearings in circuit court.
Okay.
Hi, this is, for the record, Andy Baldwin. I know it's way out and Rick, it's maybe a bit longer out that Rick would want, but with 5 hard drives filled with stuff that we don't even know what it is yet, for that hearing to have any meaning, I would think that's an appropriate amount of time, but I haven't talked to Brad about it. Of course, he may disagree.
I do not. June 30th is fine, or the week of June 26th I guess, to be more precise.
I can't do that week. I am teaching that entire week. That's why Judge Diener is gone, as well, and that week is available in circuit court. Jody is indicating June 16th is available.
I'm fine with that.
Let me see. Let me check.
Judge, might I ask? And maybe defense is better. Well, how long does the court anticipate this let bail hearing to take?
Well, it's on you, Mr. McClelland. I don't know how many witnesses you would anticipate calling. We can start as early as 8 o'clock in the morning on June 16th and go till we're done. Mr. McClelland, if it takes more than the day, is the court concerned that that's a Friday and have the weekend splitting between that? No, I'm not, unless you are.
No, that's fine, Judge.
Okay. I mean, do you anticipate it taking more than a day? That's what we had it set for originally.
I don't think so. At least from my standpoint, Judge, in terms of the evidence I'm going to put on, I don't anticipate it taking more than that, but I'm not sure what, and maybe the defense doesn't know at this point what, if any, evidence they anticipate putting on.
I'd say that's hard to say, if we put on any evidence, what it would be, just because we haven't really gone through this, especially the stuff we got on Monday, so I don't know. Brad, do you have an opinion on that?
I think is there a possibility, just to be safe, that we could tee it up on Thursday instead of Friday?
If we have to. I mean, my trial schedule is I'm in a trial every week from now until the end of my career, I feel like, so I can have one of my colleagues cover something if you want to start on June 15th, and we could do the 15th and the 16th.
I think that sounds like a reasonable way to approach this, 'cause you never know with just all the logistics. We could have things that cause some delay, maybe some technical issues, who knows? I think Thursday's a better day, if we can do that.
Do you want the 16th as well?
I agree. Yes.
Yeah, 15th and 16th.
All right. What time do you want to start?
8:30, I'm fine with either.
Yeah.
I don't have an opinion, Judge. Whatever's most convenient for the court is fine with me.
Okay. Why don't we go June 15th at 8:30, and we'll reconvene on June 16th if we need to. That way, we've got both of those days set.
Very good.
Awesome.
Okay. Do you want to go ahead and pick trial dates?
I mean, does that seem a bit premature at the court? Judge, I'll kind of defer to you on this. I mean, if you're more comfortable just having a couple dates on the calendar so the media has something to talk about, that's okay with me. But I don't know if I'm fine if we just waited until June and discussed it, personally.
Yeah. We're starting, Brad and I, Judge, are starting to realize kind of the enormity, if we didn't already know it before, we now know it for sure, of the ask at hand. And I don't know your style of, Judge, I've heard a lot of good things about your style, very straightforward and so forth, and so I'll be straightforward. I don't see this thing getting tried. It would be shocking to me if we could be ready by the end of the year. I just don't see that. Brad, am I speaking out of school?
No. I think that that's a fair assessment based on what we've been confronted with discovery.
I'm sorry to say that, Rick, but...
Yeah.
But it's up to the judge anyway, so it may not matter.
Well, I mean, just as long as we all understand, gentlemen, that this is being continued on defense motion, so all of the criminal rule 4 time is counting against you.
Yes.
And clear, and I know that you've had conversations with Mr. Allen about criminal rule 4 and the import of that, so, I mean, if you want to have a trial setting on June 15th when we come down to do the bond hearing, I'm happy to do that, as long as everybody understands the clock is ticking against the defendant.
Yes.
I understand that, Judge. And I think, the intention. We're talking kind of outside of the courtroom here, and the intention is for us to order up some depositions in April and May, and I really think that the defense will have a much better idea of how to address some of these timing issues once those are finished. So, if we bump this out into June and just address them at the June bond hearing, I think that that makes sense.
Mr. McClelland, what is your position on that?
Judge, again, as long as it's clear that the time for criminal rule 4 purposes is taken against the defense, then I'm not in a position to object. I understand it's a tremendous amount of discovery to go through, and so, as long as it's on defense's motion, the state doesn't object.
Okay. Then, I will grantee the motion to continue the trial and schedule this for trial setting June 15th at 8:30 in Carroll Circuit Court. I will have the motion to transport Mr. Allen to the Carroll Circuit Court for that morning for that hearing, and if we need to keep him overnight and if we need him on the 16th, I guess my preference would be not to transport him back and forth for his comfort.
That's acceptable.
Okay. Is there anything else on the record that we need to talk about, Mr. Rossi?
No, ma'am.
Mr. Baldwin?
No, Your Honor. Thank you.
Mr. McClelland?
Judge, I did file a motion for a protective order for discovery purposes. It's probably covered under the gag order, the court order, but I thought perhaps maybe we could address that on the June 15th date or beforehand, whatever the court deems appropriate.
Have you had the opportunity to review that, Mr. Baldwin? Mr. Rossi? The motion for protective order.
I have.
What is your
Yes.
position on it?
Judge, I don't really have any kind of consternation about it.
Okay.
There's a paragraph in the order, if I could just mention. Paragraph 5 in the order basically prohibits, anyone that we would share, well, it requires us to redact, personal information, identifying information, in the event we share it with any experts, and I can just tell the court, that's gonna be a pretty tall task considering, again, the voluminous nature of the discovery. I don't want to get overly mired down in the technicalities here, but I suspect the prosecutor's office has done a lot of that through their software program already. I do think that you're gonna get a good faith, effort by the defense, if we were to share this with someone, that we're gonna make a good faith effort to protect that information, but for us to hold us to that high standard of redaction of all the information, I think is a bit overreaching.
What are your thoughts, Mr. McClelland?
Judge, we have done our best to redact the protected information. The state's theory is that if we miss something just because of the voluminous nature of the discovery, that if that stuff is released to an outside party, whether it be an expert or someone else on the defense team, that information could possibly get out and hurt either a witness or somebody else involved in the case. And so that is the reason for that, Judge. Again, we tried our best to redact all that information. We just want to make sure we protect all the parties involved.
Okay. All right.
Your Honor.
I don't have a problem, go ahead.
Yeah, just offered a solution here, Judge. Look, I'd be happy to retain a ledger of anyone that we generate or offer this information to during the course of the case as a confidential ledger, and then have them sign an NDA agreement that just says, hey, you can't distribute or disseminate any of the information. And I think that satisfies. That concern.
I think that's a good idea. Thank you, Mr. Rossi, I appreciate that offer. I'll go ahead and grant the motion, then, for a protective order regarding discovery with that understanding with the defense that they'll keep a confidential log and instruction to anybody that they provide this to. I'm assuming we're talking investigators and experts. I can't imagine this going all over the place, so I'll hold you to that, then, Mr. Rossi, Mr. Baldwin. Anything else from the defense?
No.
Okay.
No, Your Honor.
Mr. McClelland, did you have anything additional?
No, Your Honor. Well, I guess one more thing. I assume the omnibus hearing will be continued to that June 15th date, as well.
The what? What that again?
The omnibus hearing.
Yes.
Okay, Judge. Nothing further from the state, then.
Okay. I will tell you that I have received another media intervener's renewed motion to intervene and another motion to grant public access to the state's verified request to prohibit public access. I know it was filed, you have access to TS, filed on February 10th th. When you filed, Mr. McClelland, your request to prohibit public access, I opened up the information and the affidavit for probable cause. The media is now demanding, the motion didn't incorporate the actual request that you made. The media is now asking for that request.
Judge, I was trying to pull up that request quickly here, but...
Yeah. You filed it October 28th.
Just to make sure I'm clear, when I looked at this, the media is asking him to disclose the formal pleading that he filed requesting confidentiality, right?
Right.
Just the pleading?
Right.
Okay. All right. To the extent we have a dog in the fight, I don't have any problem with the disclosure of it.
Okay. Nick?
Judge, I'm not sorry.
Go ahead.
Thank you. Judge, honestly, I don't have an issue with that. I believe the pleading just talks about why I conceal it in terms of the rule that I use. I can't seem to find the pleading now. I pulled it up. I should have pulled it up before today, Judge. I'm sorry. I didn't know we were going to address it today. I don't believe there's anything in the pleading. There it is. Let's see. Judge, yes, the state doesn't have any objection with releasing that to the public as well. And again, it's just a standard pleading to keep the records prohibited, and it doesn't list any sensitive information in there that I can see in terms of witnesses or the other things that the state or that the court has determined should remain confidential.
Okay. I didn't either. I looked at it and I'm not sure why everybody's clamoring for this, other than it's been sealed, so I'll grant that, as well. All right. Nothing else then that we need to talk about on the record? All right.
No, Judge.
And thank you, I really do appreciate the consent of the parties to do this by Zoom. You saved me a 6-hour travel down and back, so thank you, I do very much appreciate that, gentlemen. All right. See you in June. Thank you. George, you can.
Rick, we'll talk to you soon.
Judge?
Yes?
Are we gonna have another, maybe a telephone conference here after we have this hearing or?
Yes, yes.
Okay.
I'll call you.
Is your staff gonna direct?
I'll call you.
You're gonna call us, okay? Very good.
Yeah. All right.
Thank you. This concludes the proceedings at hearing conducted February 17, 2023, in this cause.